morning, everyone. This is Marina Danielyan with another episode of Future of Europe. In today's age of interconnectedness, the challenge of managing our online identities and navigating privacy concerns has become increasingly complex. As an interviewer, I'm excited to welcome a master's student in international and European law at Catholic University of Lille, Melisa Elkaya. Hello, Melisa.
Hello, Marina. I'm honored to be here.
Today, we're eager to hear your insights about the case marked by the reference C-460/2016 before the Court of Justice of the European Union that directly addresses these concerns. Could you share your expertise on this matter?
Sure. TU and RE are involved in a legal dispute with Google LLC, and TU is a board member and sole owner of an investment company. RE is TU's former partner. The issue originates from critical articles posted about TU's company on a website, which accompanied by photos of TU and RE in luxurious settings. These articles and image appeared prominently in Google search results for TU and RE. TU and RE asked Google to remove the links and pictures from search results. The dispute originated in Germany and escalated to the Court of Justice of the European Union. The case involves interpreting the General Data Protection Regulation, which we call GDPR, and Directive 95/46/EC.
Could you please talk about the Set Directive and the GDPR?
Data Protection Directive, DPD, is a set of rules to protect personal data and regulate its processing within the EU member states. It ensures that personal data is collected and handled responsibly with respect to individuals' privacy rights. So the individuals should be informed when their data is collected and when their data is shared. Personal data should only be used for specific purposes and that it was collected for. Individuals should give consent and personal data should be kept secure from unauthorized access. Individuals should have right to access and modify their personal data if it is not correct, and data collectors should be held accountable for following these principles. The GDPR is more modern and comprehensive data protection framework that replaces the DPT. Personal information such as your name, address, email, even shopping habits or medical records is likened to a treasure chest. The GDPR acts like a lock, ensuring that only authorized individuals can access personal data and its use appropriately. Under the GDPR, individuals have more say over their personal information, and they have a right to know who's using their data, how they're using, and how long it's going to be stored online. Companies and organizations handling personal data are obligated to keep data secure from cyber attacks and only utilize it for disclosed purposes. It requires companies to clearly disclose how they collected and how they utilize the personal data. Individuals possess the right to request for data deletion from their company's personal databases. This ensures that individuals can control the retention of their personal information.
Okay, thank you for this clarification. And could you go back to the case and provide a little more details?
So the debate revolves around the right to be forgotten principle, and this principle entails when Google should remove links from search results.
So what is this right to be forgotten, and how does it affect the individual's control over their personal data?
The right to be forgotten is outlined in Article 17 of the GDPR, and it allows individuals to request companies like Google to remove their personal information from online platforms, including research results. So this could include all social media posts, news articles, or any content that is no longer relevant or inaccurate. The information should be outdated, irrelevant, or no longer necessary for its original purpose, and there should be no compelling reason for it to remain accessible. The right to be forgotten must be balanced with other important rights, such as right to information and freedom of expression. If the information is deemed to be from the public interest, such as relating to a crime or a public figure's conduct, the right to be forgotten may not apply.
Well, it seems to me like it is a crucial aspect of privacy protection in the digital age, helping to strike a balance between personal rights and societal interest in the online realm.
Exactly.
So what are the key arguments that were presented by the parties involved?
So the plaintiffs, TU and RE, claim that the articles contains inaccurate and defamatory content, and this is violating their privacy and data protection rights. And they emphasize that Google's responsibility as a data controller is to ensure accuracy and rectify or erase inaccuracies. Google's argument for all this is that articles and photographs are of public interest, set in a professional context, falling under the freedom of expression and information. They highlight the practical challenges of rectifying accuracy of content not created or controlled by Google. And they also stress about the excessive obligations hindering the flow of information online.
So, in essence, we do have a clash between the privacy and data protection on one hand, and the freedom of expression and information on the other hand. So, what was the court's stance on all of this?
So, the court's decision about dereferencing links was that search engine operators must balance the right to data protection within the right of freedom of information. Dereferencing links is allowed based on reasonable evidence of inaccuracy provided by the data subject. So this can be done without requiring a judicial decision, which is prior. Search engine operators must consider that the informative value of photographs independently of their original publication context, and this will ensure a balanced consideration of competing rights under the Charter of Fundamental Rights of the European Union.
So, what are the reactions of the responses of the public following this decision?
Experts from digital rights groups say that the ruling should prompt big companies like Google to change how they handle content removal requests. So rather than relying on automated programs, they should invest in better trained staff. And this shift could lead to more responsible and transparent content moderation and protecting privacy rights while still allowing access to information. We have to keep in mind that this ruling only applies to EU member states, so individuals outside the EU cannot go to Google and ask for their removal from their content. And this underscores the importance of international collaboration for addressing the privacy issues online. So we have to keep in mind that Google has faced millions of requests to remove content from search results since 2014, and this illustrates the significant impact of this law on search engine operators.
With that being said, can you shed more light on the recent developments between Google and this right to be forgotten within the European regulations?
Yes, I want to draw your attention to a recent development which has significant impact on publishers and journalists. So, Google used to inform publishers when links were removed due to right to be forgotten requests. And this helped publishers understand why links were removed and allowed them to challenge if this right was misused. But Google has now changed its policy and now only notifies publishers when that link has been removed without providing any details. This makes it difficult for journalists to understand if the right to be forgotten is misused to suppress important news. And even articles from reputable news outlets like The Guardian have been removed from Google searches due to these requests. So we need clear rules and accountability handling these requests to hold transparency and ensure the integrity of information access.
So, Melisa, and the final question, what does this mean for the future of Europe?
With this case, the court emphasized the need to balance the right to data protection with the right of freedom of information. This balance is crucial in ensuring that individuals' privacy rights are respected while also allowing the free flow of information online. So, search engine operators are required to consider dereferencing links without necessitating a prior judicial decision, providing a more accessible avenue for individuals to protect their privacy rights. The court's response sets a precedent for future cases involving similar issues, establishing a framework for addressing conflicts between privacy rights and freedom of information. It reaffirms Europe's commitment to upholding fundamental rights in the digital sphere, guiding the development of digital policies and regulations in this region.
Thank you so much for joining us today, Melisa. Your insights have been invaluable for our discussion.
Thank you, Marina. It's been a pleasure to be here.
And that wraps up another insightful episode of Future of Europe. See you in the next episode.